Hello and good morning, and welcome to today's Knowledge Bank entitled Service Charge Disputes and Successful Resolution Case Review, brought to you by News on the Block. I'm delighted today to welcome two presenters, Ibraheem Dulmeer, a barrister and mediator at Normanton Chambers, and he is joined by consultant Roger Southam, who advises and consults with leasehold managers, owners and freeholders. They're looking forward to answering any questions you may have, so please use the Q&A function at the bottom of the screen, and they will get through as many as they can throughout the session. So good morning, gentlemen. How are you today?
Good morning. Very well, Charlotte. Thank you. How are you?
Very well, thank you.
Morning, Charlotte.
I'm going to hand straight over because I know you've got a lot to say and a lot to cover. So I'll speak to you a little bit later.
Thank you very much. Morning, everybody, and welcome to Service Charge Disputes and Resolution. I'm Roger Southam, and to give you a brief introduction of what we're going to cover through, we'll do a bit of background on myself and Ibraheem on our credentials and experience. We'll then go through the case study, and then we'll pull out conclusions and lessons learned. If there are questions that come in the Q&A, we'll try and pick some up as we go through, but we will definitely leave time at the end for you. So onwards and upwards. Right, so credentials and experience. Why would we know about service charge disputes and their resolution? So I have been in real estate for a very long time, about 43 years. I'm former chairman of Leasehold Advisory Service. I had my own property management company for 27 years, which I sold to Savills in 2016. I'm a fellow of the Royal Institution of Chartered Surveyors, Institution of Residential Property Management, and Association of Residential Letting Agents. I founded the UK Apartment Association, which is now the leading body for the build to rent sector. I still sit on the Administrative Burdens Board for HMRC, and I'm now speaking internationally and consult widely on leasehold and disputes. And over to Ibraheem.
Welcome, everyone. Thank you, Roger. I don't know how I'll do better than that. You can't really do better than that in terms of experience, can you? But yeah, a bit about myself. I'm a barrister at Normanton Chambers, which is opposite the Royal Courts of Justice on the Strand. I'm a direct access barrister. People could come to me directly, whether you're a managing agent, leaseholder, or anyone with a dispute. I'm a mediator, trained mediator, associate RICS member, a consultant for the Federation of Private Resident Associations, a member of the IRPN, and my main practice deals with residential leasehold matters. I have a growing defamation practice as well, which isn't really relevant here, but I also publish papers quite a bit on landlord and tenant matters. I've been writing for News on the Block for several years now, which has been a great privilege. So that's a bit about myself. If Roger can, why I've teamed up with Roger. With direct access, you can choose, pick and choose who you work with, and why wouldn't you work with someone like Roger, especially with that impeccable golfing tie there in that picture. Former chair at Lease. I used to be a lease advisor, so I met Roger there. Taught me a few lessons about wearing correct shoes, and from there the relationship grew, and we've kept in touch. Take it away, Roger.
Okay, right. Ibraheem is an excellent chap, by the way, and who wouldn't want to work with him as well? Right, so on the case study. So this is a real live situation, but we'll keep it anonymized. 3-core, 6-story block of flats built in 2008. The developer went into liquidation. There is a commercial landlord, and by that, a retail center sits beside the flats, who don't have much experience on the residential front, but extremely proficient on the retail front. They relied entirely on their management agent's expertise and for the running of the flats, and thought that the flats would be well run from that perspective. The structure on ownership was a freehold, which sat with the local authority, then a head lease to the shopping centre owners, which covered the flats as well, and then a sublease down to the individual flat occupants. Now, interestingly, in the lease, there was a separate water charge from the service charge. So the way the building was supposed to run was that there was a service charge for the maintenance and management of the common parts and the exterior fabric of the building, and the water was separated out. So rather than the water company billing the individual flats, there were meters inside the flats and check meters outside of the flats that the managing agents, porter, handyman could access. They would be read, bills would be divided up, and everything would be simple. Now, interestingly as well, there was also a separation of external and internal service charges, which added to the confusion. And quite coincidentally, when the building first started being managed, the exterior was managed by Party A and the interior by Party B. By the time it came to just after the liquidation, Party B had been acquired by Party A, so both bits of the building were being managed by the same identity, albeit from different offices, and that only added to the confusions. So, what matters were in dispute? Quite simply, pretty much everything. So, the residents had been shouting relatively loudly for quite a long period of time about the reasonableness, the accuracy, the poor management of the building. It was dirty, it wasn't well kept. Charges felt high. The managing agent were bringing contractors from a different part of the country to come and do the management because that was on their approved list. And then the water charges, there were misreadings from 2014. I first got involved in the building around about 2017 and couldn't believe what I saw in terms of the state of the building and how it had been looked after. I was originally told there was one resident who was unhappy, and when I went to a meeting, having been told, can you just go and see this chap and see if you can appease him and sort things out? It was my first trip to the building as well. I was aghast going around the building in advance of meeting him. Then when I walked into the room to meet him, I was faced with representation of about 60% of the flats. And bearing in mind, a lot of the flats were rented out and the landlords were absentee, that was quite extraordinary. So I was less than pleased to be put in that situation. Consequently, after sort of spending time talking with the residents, I found myself in a position of working with them and with the landlord and being a sort of mediator in inverted commas. And it turned into a formal mediation position where both sides were comfortable that I was acting in everyone's best interests and could bring a resolution. So that is what we have worked on. Now, because everybody was kind of wanting to work and solve things, and it was really the managing agent that let the landlord down as well as the residents, the first thing that I did was get a resident association in place. I had a cooperative landlord, and it was going to give the residents more voice and an ability to partake and participate in the active running of the building. So we retendered the management services, got the resident association approved. The resident association signed off on and took part in the interviews for the managing agents. And so since 2019, they've had a new managing agent in place. So the kind of ongoing has been in a better place and is still in a good place, I'm pleased to say. And it gave us a watershed and a line in the sand that allowed the building to not find itself in a ongoing nightmare scenario. Now that was helped, as I said, by the fact we had a cooperative landlord. So now what about the water charges and dealing with those? So the water charges were going to be problematic and way beyond just being able to mediate openly, because they'd been charged nothing since 2016. The bills had been racking up to the water company and unpaid, and the readings weren't being taken because they were misreading. So it was an absolute basket case, really. So it felt, and at this point I'd started an association with Ibraheem, and the abilities to bring in the practicalities of a chartered surveyor and the legal know-how and specialism that Ibraheem brings to the party as a barrister. So it was a question of getting the barrister's opinion that would add weight and gravitas to a situation that would let the residents see the reality from what they needed to be paying and how it needed to be calculated, on what the landlord side needed to be taking responsibility and sorting out. So from a practical point of view, as I said, the water is charged separate to the service charge. The meters in the flats were there were meters in the flats, and there were also check meters in the hallways, and it was the check meters in the hallways that had started failing. The meters in the flats were working, but had never bothered to be read or to gain access to the flats to read them. The meter readings were being taken by the caretaker, so there we now bring in Ibraheem, and I will hand over to him, and he will take you through what he did for his opinion.
Thank you, Roger. So for the opinion, Roger's covered the dispute very well, but just to pick that up, it was unresolved for several years, an alleged failure to deal with water charges properly by the managing agents, and water charges recoverable as separate service charges. Move on to the next slide, please, Roger. So my involvement, and this is the footprint, I suppose, the framework that I undertake the opinion process. For resolution purposes, I looked at providing clarification on the lease and the relevant law, and that includes case law, statute, and also the RICS service charge code, to provide us guidance on how to look at this resolution process for an effective outcome. So it wasn't an opinion to apportion blame per se. It was an opinion to find a resolution for the parties concerned. With any dispute, what you do is, it's rudimentary, you start off by looking at the terms of the lease first, looking at the clauses and trying to understand what the clauses actually mean. In this particular matter, you're looking at whether there was a clause that outlined a separate water meter in relation to the service charge, or in the alternative, where those meters failed, whether there was a catch-all provision which allowed the landlord to recover service charges for the water in any event. So you're looking at, so I looked at the lease quite detailed, and you'd also give the alternative approach or opinion on how to interpret that lease. The main case that deals with lease interpretation is Arnold and Britton, which two of my learned friends have been involved with. That's Roland Crozier and Mark Loveday. And that's the leading authority on interpreting contractual provisions and leases. And just to read those points verbatim, unfortunately, I will have to bore you all because it's really important. The first is, you're looking at the natural and ordinary meaning of the clause, any relevant provisions of the lease, the overall purpose of the clause and the lease. Fourthly, the facts and circumstances known or assumed by the parties. And very importantly, commercial common sense, but also disregarding subjective evidence of any party's intention. That covers the lease interpretation and how I tackled that. And the next point was to look at the statute. And that's really going back to the basics and looking to see whether those water charges were recoverable as service charges. And there's no doubt whatsoever that they were. So section 18 provides that clarification. And as I said, it was clear that those water charges were recoverable as service charges. And that means, very importantly, that leaseholders have that protection that have been afforded to them by the legislation. And if Roger could go to the next slide, please. Section 19 is where the protections are afforded. And that's where the law provides that the service charges have to be reasonably incurred and services must be provided to a reasonable standard. I'm sure the majority of you listening know that already, but that really does focus on when you've got a service charge dispute, you probably need to go to that section and take that into account, and especially in light of case law. And the next slide will go through that two-stage test that needs to be affected, whether the landlord's actions were appropriately affected in accordance with the lease, with the code, which I'll go through later on, and the 85 Act, which we've just discussed, and also taken into account whether those charges were reasonable in light of evidence. In addition to that, with water matters, you've got additional law, and that is the Water Resale Order 2006. Not to go into too much detail in relation to that, but what people have to be aware of here is that where a leaseholder pays the landlord for water, there is an additional level of protection that is outlined in that order. And what the resale order covers is who the regime applies to, and it was clear here that the regime applied in this particular scenario. There are a few legal principles that were covered in the opinion, and not to go through them in detail, I would like to just skip over the first two and focus on probably the most pertinent one, which is across the board. And that is the fact that service charges are service charges are a statutory trust. So whenever a service charge is paid, then you've got a service charge trust, a statutory trust created. So if Roger can move over to 2 slides. And that's under section 42 of the Landlord and Tenant Act 87. And as I said, where service charges are paid, they're held on trust, which means that the landlord or the agent has to act with due diligence, and they have a fiduciary duty to use that money and be aware of that duty. Right, so this was probably the most amount of case law that I've dealt with in an opinion thus far at my time at the bar. And I looked over 200 cases, and those were first-tier tribunal cases that dealt with water charges, to see whether there was some guidance that I can get. And as you can see there, you can see someone probably in Mauritius somewhere having a deep dive, and that's what it felt like. Probably not that nice, however. Looking at the first-tier tribunals gave me an excellent insight as to the approaches that a tribunal judge would take in relation to these water charges, and gave an indication as to what the tribunal may find, and that was highlighted in the opinion. However, it is really important that when people do look at first-tier tribunal decisions, that they're not binding on another tribunal, because they're not a court of record. A few of the decisions I'll discuss now. First-tier tribunal had a few very, very different approaches. There was one case which applied the water resale order and reduced the water service charge. Another made it clear that the landlord had to demonstrate that the monies were in fact due. And thirdly, in some cases, there was a reduction in the water charges, but with no real explanation. Looking at case law which is binding on the tribunal, and that's the upper tribunal lands chamber cases, There was a decision that made the sum for water payable in full, but again, lacked explanation as to why. Another decision dealt with the responsibility was on the landlord to demonstrate that the monies were owed and they were to be paid by the leaseholders. And the final decision that I'll discuss in this particular slide is that the water resale order applied to water charges, but could only be recovered up to the cost of representing a reasonable consumption. The RICS code was very important here because it directed the parties to looking at the regulatory authority that dealt with water, and that's Ofwat. So paragraph 9.6 of the code highlighted that. And what that did is prompt the landlord to obtain further guidance as to the setting of the charges through the service charges in the future. The opinion actually ended up with additional points, and those were practical points for the parties to consider. And that was looking at the current meter and functionality and how to actually improve the current position. For instance, looking at radio signals to be used to recover the actual water meter readings, obtaining guidance from the Consumer Council for Water and the actual water supplier and having their input in the matter. But ultimately, it was really important to ensure that with any outcome, that the safeguards to the leaseholders' interests were taken on board. And those are the points, I believe.
Indeed, Ibrahim, thank you very much. So now, having got Ibrahim's excellent opinion through, the practical elements of using that and adding that into the work that was being done to resolve matters. First thing I did was share the opinion with both the resident association and the landlord, so that everyone knew where they were standing from the legal perspective. It was then a question of engagement and looking at the findings and the way forward. Now, for the first time, we had an admission out from the leaseholders that they had to pay for the water, and it wasn't a question of there was any way that they wouldn't be paying for the water. It's a question of reasonableness and a question of how to retrace steps and recreate history to actually get a reasonable perspective. So one of the things that was done was finding average charges from the water company, ascertaining information from Ofwat that allowed us to get to a reasonable and fair position and perspective that gave each of the leaseholders their reasonable water charge, even though we couldn't recreate the readings, we couldn't go back and know exactly who had been in each flat for how long. A lot of the flats had absentee landlords, some were rented out, some were used for visiting purposes from traveling outside of the city. So it was vital that we kind of had that averaging aspect, and getting reasonableness across all of the flats was where the kind of problem had started in the first place. So we produced an analysis of the flats with the accurate readings and the average charges. And basically the matter was resolved from pragmatism and fairness. And it was addressed entirely because of having engagement and clear communication, and the barrister's opinion that gave a credence, credibility, and weight, gravitas to what was trying to be achieved. Now, one point that Ibrahim made that I will pick up on, because I think this is absolutely vital to any situation that either leaseholders or landlords or managing agents indeed find themselves in. And it's vital that you start off not blaming the other side, but actually seeking to resolve matters. And I think you know from your own experiences that if you're painted into a corner, you tend to react worse than if you've got someone who's trying to work with you or someone who's trying to address matters. Now, in some situations, there will be parties who don't want to work with you, who don't want to resolve matters, who don't want to see a resolution. But every now and then, it is useful to have a practical perspective that may find that commonality of ground, that may find that essence that allows for people to derive a solution. We've just had a question in actually on no comments on the 18-month rule, which is an interesting one. So 18-month rule is applicable on one part of this case, but not on the water matters. So the reason the 18-month rule wasn't relevant on the water charges is everybody knew that the water bills were there and they'd had notice. What they hadn't had was the practicality of being charged. And also from the water's resale order, there is a presumption that the residents must pay for the water. The fact it was split out from the service charge is what kind of removed it from that element and aspect. I'll bring Ibraheem back in a bit to comment further on that. So just moving on to the generalities from this particular case and how it was successfully resolved. I think, and it comes back to that blame point, there was a willingness of the landlord and the residents to try and derive a solution. When I first got involved, there was an entrenchment, I think would not be too strong a word, of the residents who were very, very upset, and quite rightly upset, for the state of the building and the way that it had been managed and the way that they felt they'd been ignored and not had their questions answered. And that is one of the things that I bring to the party, of trying to get everybody out from the trenches and actually standing together to try and seek the common ground that will lead to a resolution, rather than the expensive outcome of going to tribunal, which at the end of the day is really, really, really should be a last resort option. There was a balanced view on the liaison and handling between the parties, which helped, that came from that common ground. It goes without saying, as I've just mentioned, the benefits of avoiding tribunal litigation, which can be horrendously expensive. And we could debate and argue about the rights or wrongs of how a landlord can charge their costs down to the leaseholders, but a leaseholder has no recourse to recover their costs, even if they're successful. There is Section 20C in going to tribunal, but anything you can avoid in that is obviously useful. It was helped considerably, and I don't think we would have got the same resolution on the water without the barrister's opinion, and using that expediently was a linchpin and a turning point in what we were trying to do. There is always a necessity for some pragmatism and looking to the future, and how do we get the past behind us, and how do we make sure that you're not living in the hell you've gone through, and you can actually find a positive way forward. At the end of the day, these are people's homes, be it the renters or the leaseholders. If it's the leaseholders, it's their investment, but it's the renter's home. If the leaseholders are living there, then it is their home, and it wants to be treated as their home, and they want the respect of it being their home. And the matter was resolved through negotiation and communication. And I cannot stress enough the needs of good, clear communication with both sides and finding that common ground. So now, moving on to the lessons learned. And if Ibraheem wants to jump back in, then we can pick up questions as we go. I think the main one that leaps out for me is that it is easier to manage the buildings than it is to let the problems build. Now, there's been a lot of work done by IRPM over the pandemic period on the stresses and strains on managing agents and their mental health and wellness. And from a survey that was recently concluded, there's an awful lot of managing agents who look like they'll be leaving the industry. Now, for leaseholders who don't like their managing agents, they might go, well, that's good news. But at the end of the day, they're human beings. And would you want your spouse, yourself, your kids to be treated as some of the leaseholders treat the managing agents? And the answer is probably not. So I think there is a necessity for respect at all levels. I think there's a necessity to, even in bad situations, to try and work with someone. But as I say, if the building is well managed, it avoids an awful lot of the problems happening in the first place. And there probably needs to be a greater understanding of what impact and effect bad management can cause to the leaseholders and their properties. It is far easier to bring in help than it is to get resolution at the tribunal. I presume Ibraheem will jump in and comment on that one. What are your thoughts on resolution versus tribunal, Ibraheem?
It's quite simple, isn't it? You try to resolve the matter informally with formal backing, as it were, to understand the legal position of each respective party before you were to go to the tribunal. Of course, the tribunal is the last port of call. You won't necessarily run to the tribunal straight away. The stresses involved, the time it takes. The last time I've checked with a tribunal, you're looking at a 12-week just to get to the first case management conference at the moment. So it's a long process, especially where this matter was entrenched in terms of the time it has taken to get where you were. And you know, you needed to find a way forward, and finding that way forward with de facto mediation service using a barrister's opinion was helpful in my view. And hopefully, as I say, and this can be used across the board in the leasehold sector as a way forward to avoid tribunal, to avoid not only avoid the tribunal, but also avoid acrimony. You want to ensure that each party understands the other side's perspective, and then at the same time reach a resolution on that basis.
Yeah, I think I think that is the essence. It is a question. I mean, it's kind of taking the emotion out of the situation, and that's always the hard thing to do. And when you've got entrenchment of any situation, taking the emotion out becomes an absolute nightmare. But where a third party can bring a lot of value to that solution or that situation is avoiding a very, very expensive case. I've got another situation running through my mind that is ongoing for me at the moment. And I've got bought into a leasehold enfranchisement that has been 3 years and still going. And the fees have been racked up by the landlord. Oh, sorry, for those listening who don't, or watching, leasehold enfranchisement is extending your leases when they drop below, or when you want to get a longer term. So again, from a practical and a pragmatic point of view, one could spend a lot of time arguing backwards and forwards on technicalities. And my God, the lawyers had managed to do that between them the solicitors had managed to do that between them on racking up fees, arguing that a dog is a cat, and just unbelievable. So rather than entertaining that, I have just cut straight through to the landlord and seeking to resolve matters directly. And interestingly, the client said, oh, her lawyer hadn't heard from the other side's lawyer since I'd been involved. So I said, well, that's been deliberate, because I told them to stop racking up fees and stay out of the picture until I've got it sorted. And then they can do the documentation, because all they were doing was just clocking up hours and hours and hours, arguing backwards and forwards. And the most idiotic of it, and I think idiotic is the phrase, they were arguing about whether the latest notice was valid or not on how the solicitor had signed the document. Now, rather than just reserving the notice and doing what the landlord was going to be happy with and making sure it was right, which would have been a couple of weeks difference, the solicitors had racked up 2 months of arguing backwards and forwards. They'd got a barrister's opinion on the signature and whether it was right, wrong, or indifferent. And you look at it and you think, seriously, guys? And then the solicitor says, oh, you don't want to do that because it might cause this. Well, it hasn't caused anything because I got agreement from the landlord. If I'd reserved a notice, had it signed by the owners, that everything would be fine. And everything is fine. And it's a practical and a pragmatic solution. And I think that's where the kind of combination of the sort of practical charter surveying and the legal barrister element works well and dovetails well together. We've got one question.
Sorry, Roger, can I just come in on that? I think that's a very fair point. Of course, we tarnish all solicitors with the same brush, but there is the fact that where you've got a direct access barrister, that the fees are set, they're fixed, so you're not paying for a phone call. Or say, for instance, you've come back to me for clarification, I will give you that clarification on the basis that, look, it's just an hour or so, or just reviewing the questions and coming back to you. So you've got that flexibility that the bar provides with the direct access service. I think that's something that many people aren't aware of. And this is probably, hopefully, a good platform for you all to be aware that, you know, you can go directly to a barrister. Don't necessarily need a solicitor to engage with me through, well, they don't need to come to me for you to get to me. So I think that really hopefully does change the landscape, where whether it be a leaseholder, a managing agent, picks up the phone and says, Ibraheem, I need your services for an hour, give me a fixed fee. And that hopefully helps the industry improve, because of course there isn't that phone call service that you can obtain for managing agents, is there, Roger? Where someone can call up a barrister or a legally qualified opinion, obtain a qualified opinion without engaging them to a huge extent and putting money on account. Next thing you know, you're thousands of pounds down. And one of those questions, which is very pertinent, is, you know, does the lease allow for the recovery of the costs? An excellent question, Helena. And of course, that depends on what the lease provides. And in that particular situation, I wasn't instructed to advise on that, but perhaps Roger can pick that up.
Yeah, absolutely. So yes, the lease does allow for the landlord to recover professional costs. However, the landlord didn't have any appetite or interest in just digging their heels in and trying to exploit or upset their leaseholders more than they were already upset. I think there was an advantage that it was a professional landlord in the retail environment, so understood customer service, understood working with tenants, and their sole motivation was getting a resolution that was fair and reasonable, and that the leaseholders and they were the innocent party. And how do we get matters addressed and resolved that leaves both parties kind of where they should have been, had everything run properly? And obviously you can never completely repair that, because you can't go back and make the building clean. You can't go back and get everything working smoothly. And some fairly vitriolic emotions, comments, and attitudes had sort of ensued. But what you can do is kind of repair some of that and sort of look to what a good managing agent can do, the tendering process, the engagement with the leaseholders to actually be a party to that transactional element, to acknowledge that they're picking up the costs and they're picking up that aspect. So yeah, the landlord could quite easily have dug their heels in and gone, I can recover my costs, I'm happy going to tribunal, but it wasn't really going to solve anything. It was only ever going to make it worse. It's that kind of Armageddon situation that you'd probably find yourself in. in those situations. What about the 18-month rule? Any comments on that as a generality, Ibraheem, rather than specific?
As a generality, you're looking at the water resale order, so that trumps the 18-month rule in my view.
Yeah.
So it's quite a straightforward answer, and that's the approach that we took, in the opinion.
Yeah, I think it's that whole aspect of there's an awful lot of legislation that intertwines and overlaps with each other, which then when you add in the case law, and you'll frequently find that there are first-tier tribunal cases aplenty for any specific item you're looking at, but not much in the upper tribunal. Now, the frustration of first-tier tribunal is it is not binding. It is only guidance. It's only illustrative of what could happen. But as Ibraheem pointed out during his slides, what it does do is give you a very, very good perspective on how a tribunal may think and how a tribunal may decide on something. And certainly from an adding weight point of view in any discussion and any ability to resolve things, it gives you that comfort that this is what was done before. It should go this way unless there's something fundamentally different about matters or fundamentally at odds with where things are sitting. So it's one of those practicalities, and it's one of those elements that helps the cause of knowing the first-tier tribunal cases. But as I say, you cannot categorically say that is what would happen.
Absolutely, yeah. You wouldn't be able to rely on those FTT cases. So they give you a flavour of what the tribunal may determine in that particular matter. But of course, the factual matrix may be totally different in your circumstance. So it's important, in my view, to get that specialist advice to understand what your legal position is, looking at the lease, interpreting the lease, then looking at any codes that apply, the RICS code, looking at the statutes that apply, and then coming up and forming a view with a way to resolve the matter. I've got another question there, Roger.
Yeah, so we've got someone keeping their head down. Why do you think a chartered surveyor can give a better solution than a solicitor in service charge matters? Well, I think it's the practicalities, and it's the understanding management, and it's understanding what co-joins and sort of separates both parties. So it's not about solicitor bashing in any way. It's not about saying that they're not appropriate at any point in time. It's knowing where there is the practical aspects to it over and above the legal aspects. And then where you get the legal aspects, I would take a preference of a barrister's opinion, which carries more weight with it than a solicitor per se, and those solicitors will go off to barristers to get opinions quite regularly. So with all respect to solicitors, they're never going to have my 43 years of property management experience in bringing to the table the practicalities of how does this actually work. I was in a case, a very, very high-end case that actually made the Evening Standard from, I think I'm safe saying this, some Russians who had fallen out on a building in the West End of London. And it was owned, the building was owned freehold by the leaseholders, if that makes sense. So the leaseholders owned the freehold. And they'd fallen out badly over the quality of services that were being provided, and one faction wanted far higher end services than the other one who were trying to save money. And I got brought in on one side as an expert witness, turned up at court, and the solicitor painted a picture of how the management would run. And in one fell swoop, lost the case for his side because he had no comprehension of how you would run a building, how you would manage a building, the practicalities of what was needed. So in about 5 sentences, I was able to not only unpick their argument, but also prove the kind of that the other side were kind of in the unreasonable camp to start with. So there will be some cases that are more legalistic and some cases that are more pragmatic and practical. Service charge tends to be the practical and the pragmatic. And in all the cases that I've taken to tribunal, acting for leaseholders and for freeholders as well, it's always been the kind of practical and the pragmatic. And my track record is pretty strong at tribunal, because even against a barrister at tribunal, again, they won't have that practical experience. And that's where I think Ibraheem and I work well together, because he brings the legal gravitas to it. He brings that capability, but from what would you do, how should you do, what's reasonable, it's that practical and pragmatic element. Right, Stuart has a question for us. I need to move. I think we're now on full screen with you guys, so I need to do that. Right, my lease does not allow landlord to recharge legal costs via service charge. Does that make it more effective for leaseholders to take landlord to FTT? Right, without seeing your lease and without going through, I would be looking at other clauses than just the service charge to see if there is some ability for the landlord to recharge under one of the other practical general clauses that would be directed at the specific leaseholders taking them to tribunal, rather than actually recharging it through the service charge, because it may not be, because if you have, let's say there's 100 people in a building, 20 are upset and take the case, 20 out of the 100 would face the costs, not the 100 necessarily, unless the landlord is a complete and wants to put it through the service charge. So in your case, right, Stuart's now said this has been confirmed by lease. So there's no other clause in your lease, Stuart, that is for the individuals. Then if there's no clause in there, Ibraheem, there's nothing they can charge back through the lease. I
wish I can answer that question through this webinar. It's impossible to. You'd have to look at the lease in detail. You know, I can't comment on the advice that you've already sought and confirm or deny it. But what you have to be aware of, there are several aspects that you have to be aware of, is that it's not just about the cost issue, number one. If, for instance, there are costs involved, there's still the tribunal rules that are important. So you're looking at Rule 13 as well, and that deals with unreasonable conduct during the litigation process. So have a look at the rules, the tribunal rules, before you even embark on that. And if clarity is needed, of course, get that legal advice. Initial legal advice is great. It's fantastic. But sometimes when that's used incorrectly, that can actually harm your case rather than help it.
Right. Sorry, we've got a long question in which I was reading reading through. So Samra says, I am one of the leaseholders who is FTT applicant in North London development. We sent statement of case 4 weeks ago and received the respondent statement of case yesterday as response. There are quite a few incorrect statements which we deny. In replies, they show tendency towards apparent deliberate obfuscation in this regard. It is unbelievable. Do we respond to this statement? As per tribunal directions, the applicants may send a supplementary reply to the respondents. Please do we respond to this statement with facts which we already stated in our SOC and expand more to divert from the response? Right. So this I've come across a fair bit. I know Ibraheem is going to say, without knowing the details and without knowing anything else, he won't comment, quite rightly. And this is where, again, you get the practical chartered surveyor who will happily draw a conclusion and then caveat it very heavily and say it depends on the circumstances. But as the generality of what you're asking, I would always say do a reply to the statement of case, because if you don't do a reply, you've got nothing recorded with the tribunal saying how you see what they've presented. It is not unknown for landlords or for other side, or for the other side as well, to obfuscate and be a little bit economic with matters, I think would be the nice way to put it. And it's one of the elements that if there's an ability to cause confusion, someone will try it because it can be a diversionary tactic, and it can obviously string out, particularly if you've got a case that is set for a number of days or a specific time period. Then anything they can do to delay or spin out will add to that. But without having full knowledge, I would always reply to the statement, particularly if you believe some of the points are incorrect. But the challenge is keeping yours as concise and focused as possible. And it would feel like there needs to be a reasonableness in what is handled and put forward, because I would suggest that just going back at kind of loggerheads, the analogy I would give you is like judo. So if you're going to throw someone in judo, you don't just run at someone and butt at them, which generally hurts both people and you as much as the other side. Whereas if you use the other person's body weight and lean in and let their body weight go, it is more effective. Therefore, if you can find some commonality, some bits that are correct, you will add more gravitas to yourself by saying, oh yes, we accept this is right, we accept this. However, and it's that kind of whole leading round. So there's a whole messaging and massaging. Sorry, Samra's come back in capital saying they are in breach of lease as they did not do external and internal decoration every 4 years. Last decoration was done in 2014. Now they say they could not due to Corona. Corona is since last year, not since 2018. Yeah, Samra, I think that's a reasonable point. And yes, absolutely, they should be done every 4 years. And that's what it says in the lease. And that is absolutely right. And you are perfectly correct. However,
Roger, can I just come in on that very briefly?
Yeah.
So back to Samra. I mean, if the tribunal have made that a possibility that you can reply substantially to a reply that you've got from the other side, then follow that direction carefully. It's a very simple answer, but support what you say by using evidence. Not just say that you disagree with what they say, but explain why, provide the evidence, and so forth. You've just given an example. Again, provide the evidence, photographic evidence or otherwise, and that should be really helpful, I hope.
Yeah, and the other the point I was going to add on the end of that was a tribunal. I know this because I've had this actually happen to me in one case, where the tribunal judge will say, well, the decorations haven't been done, but you haven't had to pay for them. So you need to look carefully at the grounds and what you're actually arguing on and what you're in. Oh, we've got a 6-minute warning flashing up on us, Ibraheem. We've got red lights.
There you go.
Right. So, Roger, in the original case discussed, presumably RTM wasn't an option due to the extent of the commercial premises within the development. If it had been possible, however, would you have recommended it to the leaseholders? Yeah, absolutely. I think if leaseholders can get RTM, it is the most sensible thing to do. I've got another case ongoing at the moment where we're trying to get a resident association, but in getting the resident association, we're trying to get the people signed up for an RTM at the same time, if that makes sense. So the fallback position is they will have an association, but the best position will be that they have an RTM. And I think, again, it's that practical and pragmatic aspect whereby you can, in collecting signatures and people's supports, gather both things effectively, because the resident association is going to be pretty much free to set up. Right to manage, you are going to incur some cost potentially, particularly if you've got a challenging freeholder. Now, not everybody would want to pay the costs, but the people who don't want to pay the cost may want to join an association. So how you message and how you put out that portrayal becomes the important aspect. So you don't miss someone who would join an association by just going for an RTM, for example, which you will have more control. Having an association, you have more rights to service charge information. So yeah, there was the commercial part that stopped them being able to do an RTM, but they've now got an awful lot of say in how the building is run, and they're working directly with the managing agent. So to all intents and purposes, they are pretty much RTM without the name and out the aspects to it. Now, Robert, does a Section 20B notice have to give details of the charge that cannot be made within 18 months, or is general to anything within the accounts we're giving you? Ibraheem, do you want to comment on that? I've got various thoughts on this one. I've got a great case.
I think what you have to do is send out demand for the payment. So if you can't send the demand, rather, Robert, for the payment within 18 months of the cost being incurred, then you send the special letter that will you'll know as a Section 20B notice to outline why, and it's a proper, it has to cover various aspects, which I'm more than happy to email you over. So you can email me and I'll be happy to send you what it has to actually encompass.
Now, interestingly, I had a case where I was actually acting for the landlord and the managing agent who thought they'd messed up badly. They were commercial managing agents and didn't understand residential at all. And their one saving grace on their year-end accounts, and I'm smiling because it was just, they had no idea that it was going to save them, was that in their year-end accounts, they included percentages and details that, whilst they hadn't actually picked up the right information, they'd given sufficient information for them to count as a 20B notice. So the luck on that was just extraordinary. And there was a leaseholder and a sub-leaseholder. It was a very complicated building, again in London, but both of them had barristers. And again, from a practical point of view, I took it from the practicality of having a document that had all the information that was necessary, whereas the barristers were looking at it from, and solicitor actually was looking at it from the legal side, that there hadn't been a formal Section 20B notice. Because I was able to structure from the practical and pragmatic, the tribunal judge went down the road and saying, well, all the information is there. You can't argue that it doesn't say Section 20B, but what else would you have on there apart from being written Section 20B? So it would be harsh for me to determine that it wasn't a Section 20B. And the client breathed a huge sigh of relief, because that was a lot of money that they were facing going out. What made it slightly worse was the sub-leaseholder had been paying the leaseholder. The leaseholder hadn't been paying the landlord, so it was kind of it ended up in a strange situation where the sub-leaseholder and the freeholder were actually both on the same side in the end. Nicholas has got a point on Brent v. Shulman. Ibraheem, any comments? Do you know that case off the top of your head? You're on mute, Ibraheem. The first schoolboy error you've done. Unbelievable.
How very dare you, Roger. Yeah, Shulman B is the leading authority for Section 20B. So yeah, right. Well done, Nicholas.
Anything on that case that adds into what we've been talking about, or?
Yeah, like I said, I've invited that. Oh, there you go.
Charlotte's back. Hello,
Charlotte's back.
I'm back. I think you've got all the questions covered.
I think we have.
Are you happy with that, gentlemen?
Yeah.
Thank you very much, Charlotte.
Anybody want?
All I can say is thank you so much for hosting the session today. I think it was really useful. Loads of questions, which is always good, which shows everyone was definitely engaged with your session. All I can say is thank you very much. Join News on the Block on the 8th of June when Andrew Bannister from Earl Kendrick is going to be discussing planning maintenance or planned maintenance. So all I can say is thank you very much, everyone, and have a good day.
Bye.
Goodbye.
Thank you. And the slides will be sent out. Lovely to see everybody. Thank you.
Bye.